Start over here. We're on self-represented docket B for family law. I'm Commissioner Dave Nelson. Thank you for being here. I see Mr. Zandy's here. So I know you're waiting for Commissioner Cotterell to be back in order to resolve the issues with the order. So are you going to want to put this over, or how would you like to handle this today?
Well, I guess my client's preference would be that Commissioner Cotterell hear it if the findings that I've included in Mr. Zandy's order are disagreed.
Sorry,
So let me talk to Mr. Zandy. I'm assuming you're not accepting the findings that were in Ms. McLean's order.
No, I think it goes a little bit far afield of what Commissioner Cotterell's ruling was. Again, this was limited to just extended time over the holiday at Christmas as well as spring break of 2023. Although there was a lot of discussion, this turned into a lengthy hearing. There was a lot of back and forth on that issue. Commissioner Cotterell did make findings. However, I don't think those belong in the order necessarily as drafted. So I think that's just the dispute with that. If not knowing what his availability will be moving forward, I'm agreeable if your honor or another judicial officer wants to take a look at that and kind of interpret what was intended by Commissioner Cotterell at that hearing in December. I'm fine with that. And then you can interlineate or take out or add or subtract whatever it is that you find necessary from between the two orders. Mine's pretty basic. Mine sticks to what the ruling was. I think that's agreed. Only dispute is related to those specific findings as drafted by Ms. McLean.
Well, the heart of that order was that there would be no Christmas vacation to Spain, I believe it was. So whether it's entered today or Commissioner Cotterell will probably be back in March. Whether it's entered today or in March, I don't think it's going to make a big difference because the reason for that order is already past us. So I would prefer that Commissioner Cotterell be able to enter an order that reflects his thinking. I don't know what his thinking was. Okay.
Thank you.
Put it over to March 2nd at 9 o'clock.
Thank you very much, Your Honor.
All right. Thank you. Are there any other matters that the parties are going to ask for a continuance? Yeah, does not appear to be.
Yes, sir. I would like to ask for a continuance.
All right, I was going to call your case. So let's call that case. Is it Eliza White and Joseph White?
Yes, sir.
I saw Ms. White was here. I see you on Zoom. Do you want to unmute yourself?
It is unmuted.
No, I'm talking to Ms. White. There
Oh,
we go.
yes, sorry.
Okay.
Yes, Your Honor, sorry.
All right. Well, fortunately, Mr. White is here. This is a motion to change, I guess, visitation schedules. Mr. White was served with that, it looks like, on January 18th. He's entitled to 21 days to respond. So we haven't yet hit that limit. So Mr. White's asking you for a continuance. Let me talk to him and then I'll give Ms. White a chance to respond. Mr. White, how long are you looking for to continue this?
A week or two. So the only paperwork that I have that has any date on it says that she asked for a motion or a hearing December 27th, 2023. I don't have anything that said she asked for a court date on the 31st or anything to that nature. The only one that I have is right here, and it says December 27th.
Okay, well,
so I didn't even know it was
intended to be December 27th, 2022. Do you have the motion to reestablish visitation and the declaration?
Yes, sir. That I have it right in front of me.
Okay, good. So you've got the information that you need to respond to what's being requested. So the question is, you think you could be ready to respond in a week or 2 weeks? Is that right?
Yes, sir.
All right. Ms. White, any response to the request to put this over a week to 2 weeks?
Yeah, actually, Your Honor, Joseph has been telling me for over a year now that I just bring him to court. I do this, and he will not fight me because he wants me to see my daughter. He gave me custody of Sydney, so why wouldn't he let me see Savannah? It doesn't make sense. So, yeah, it really, I'm not understanding why he's wanting a continuation when every single time I talk to him outside of court, it's a different story. Now, suddenly, the story changes again. I'm sick of the games, Your Honor. It doesn't, I want to see my daughter.
All right. Well, again, when somebody's served, they're given a certain amount of time to respond. We haven't reached that limit yet.
Your Honor, if I may.
Yes, briefly, go ahead.
So originally when she lost her visitation, the court ordered her to meet a couple requirements.
Okay, sir.
And she met none.
Mr. White, before you launch into that, all I'm deciding today is when to set the hearing.
Okay.
What Ms. White just said and what you're about to say is going to be relevant at the next hearing. Okay.
Yes, sir.
If you want to file a declaration in response to this,
I will have a response filed before then.
Then make sure that's into the court by Monday, okay?
Yes, sir.
Mr. White. So let's come back here on the 9th at 9 o'clock. I will be the judicial officer at that time. I've read the file, so I think I have an understanding of the issues, and I'd like to hear what both of you have to say at that time, okay?
Yeah.
Wonderful.
I do have one thing. She said that I don't have an attorney, but I have an attorney still. So I don't know why we're on the docket with no attorneys. I'm not pro se.
Okay, well, this is where I believe it was Judge Hahn put you over to today on this.
Okay.
So we're going to stay on this docket.
Okay.
If you have an attorney, get a hold of them, have them appear next week, okay?
Yes, sir.
Okay, Ms. White, any questions?
No, Your Honor. Thank you very much. I appreciate your time.
Okay. All right, Lawn versus Roten. Do we have anybody from? Oh, there we are, Ms. Morgan. Good. Mr. Roten is here. So we're here to enter a child support order. Let me have Ms. Powers go first, and then Mr. Roten, if you want to respond, and if Ms. Long wants to respond, you can do that. Go ahead, Ms. Powers.
Thank you, Your Honor. We were here on January 12th for our hearing on temporary child support. At that hearing, we received information that the mother's income was different than we had it in our worksheets. So since that hearing, we've updated our worksheets and our proposed child support order. We have the father at his actual income from the last 4 quarters of employment security, and overtime was included in that, as employment security data shows overtime has been consistent at least since 2020. And then we used the mother's actual income of $21.59 an hour, 37 hours per week. We included a whole family deviation. All of this results in a transfer payment of $645. The child was on TANF through January, so we are asking for back support of $645 for the month of January. The parties had requested a residential credit. Now that TANF is no longer active, the court could consider a residential credit. The state has no position in regards to that. I left Section 9, the deviation section, left that in the child support order in case the court wanted to add to it. I also left paragraph 10 blank for the actual transfer payment and paragraph 19
and then
blank.
You just were like, I'll have another one.
Regarding taxes.
Oh, it's not even that, it's just sick.
As the parties indicated at the last hearing, they were not in agreement with taxes.
Okay. What would be a typical residential credit?
Well, there isn't a standard calculation for it. The case law says that the court has discretion in it. I know Support Calc has a way to calculate it. The program our office uses does not include a calculation for residential credit. I would note that the father's net income is $5,492. The mom's net is $2,975. So there is a pretty big difference in their incomes.
Yeah. All right, let's hear from Ms. Long first.
I've talked to Mr. Roughton, and for the most part, we co-parent pretty good. We've been doing 50-50 for a couple of years now. At this point, I really wouldn't expect him to pay child support. I know, you know what I mean? He has another son that he has full custody of. I think the issue was the primary residence. We've only co-parent. We've done the parenting plan among ourselves. So if it makes it better on him financially, because he does have our daughter 50-50 and we help each other, at this point, I don't really want the child support from him because he does. Taxes, we did agree every other year. He did claim her this year. So next year would be my year. But other than that, like I said, it's 50-50. So we both do our part. And as far as child support goes, I don't want a high payment from him because I know he has full custody of his son also and a single parent.
Is Georgia on anybody's health insurance?
She's on mine.
Okay.
I don't have her on mine yet.
She is on state medical, Your Honor.
Oh, she's all right. Is that going to continue?
Yes.
State medical. Okay.
Yes.
Okay. All right, Mr. Roten?
Yes, sir.
Any response? The state is asking for child support in the amount of $645. Ms. Long has said she's not really asking for it, but on the other hand, the state is making payments, and so they have a right to request child support.
So I just have a couple of questions just so I can get clarification. Because she took state money, she was on TANF, that's what makes me liable for paying back that obligation, correct?
I believe that, and also state medical. Is that right, Ms. Powers?
And with the state medical, our interest is having correct incomes in the child support worksheet so that DCS can enforce medical insurance provisions based on their income if it becomes available at 25% of their obligation. TANF ended at the end of January, so we don't really have an interest in the transfer payment after January, but I am asking for the $645 just for the month of January.
Okay, I see.
Okay. So because I can go put her on my insurance. If I went and put her on my insurance, would that do anything in regards to what I would be obligated to pay the state at this point?
Well, you're still going to owe the state $645
for the month of January.
Right.
So so what are we talking for the month of February and so on then?
Let me ask some questions. So do you pay anything to have her on your insurance?
I would have to pay a premium. Yes. It's like $285 to $350 a child per child, unless you do a family. And then we're talking $800 a month for that.
Okay. But we're just talking about Georgia at this point.
Correct. Yes. Yeah. That's about $350 a month from my understanding.
Okay. Ms. Long, do you pay anything out of pocket?
No,
it's all by the state.
Because she's on. Yep, it's on state medical, so I could get insurance through my work for her also. But if we can have state medical for her, I don't feel the need to get her on our insurances through our works because financially,
I would rather,
you know what I mean?
personally.
I mean, that's up to him. Like I said, I think the issue is the primary residence also, but like I said, he does have her 50-50 and we both, but she does have state medical and she's always had state medical. So I don't see the need to change it now.
Let me ask the other question, Mr. Roten. Are you okay with having the tax exemption be shared 1 year to you and 1 year to Ms. Long?
Honestly, sir, not if I have to pay child support. I don't feel that's right. I have her 50% of the time, and then I'm paying her mother monthly and I mean, there's way more expenses beyond just what I'm paying in child support. I mean, she has travel volleyball that's thousands of dollars that I get no help for, and I don't want to get into that type of stuff. But no, I wouldn't feel comfortable with letting her claim her every single year if I'm having to provide for her 50-50 as well as pay her mother child support.
Okay. What I'm inclined to do is to have no child support payment, which is, I think,
and that I'm fine with that. That's what as long as taxes go, sorry.
Let me just finish where I'm going and then you can comment.
Okay.
No child support payment, have the father cover on the medical because I think that's going to be a better medical plan.
I agree. I have Kaiser.
And then I would alternate the tax exemption.
I have no problem with that. I'm in 100% agreement with that.
Does that work with both of you?
That's fine with me. So he claimed her this year. So next year I will be claiming her.
Yes.
For 2023?
Yes.
Yes. He claimed her for 2022.
All right.
So I do, on the medical, like I said, another thing I believe at the last court hearing was primary residence. How is that going to, I mean, if we could both be the custodial parent, I'm fine with that. Like I said, I think we've been doing this since he was little, co-parenting and figuring out visitation schedules and everything. And I've been the primary parent, so I'm just trying to figure out how this is gonna work.
All right, just hang on a minute here.
And then I have a question too, Your Honor, when you get a moment, please.
I mean, we do have her 50-50, but just as when she's with me, I pay for her things too. I don't want to get into the finances because we both have her 50-50, so we both support her.
It was my impression looking at the file that the parenting plan was entered recently.
Yes.
So that was entered on January 12th.
Okay.
And let me just see what it says on that.
And were you able to read both declarations from both parties involved? I'm not sure exactly what you're talking about. I read the file to understand what the issues were. The main issue today was the child support. Correct.
It has Crystal Long listed as the main custodian.
Correct.
Okay.
And
then we agreed.
And it indicates for school-age children, it's week on, week off.
Yep.
Transferring Sunday at 5 p.m.
So he does want to do Wednesday. He did talk to me about that. And I'm going to talk to him about that. I think possibly that would be better. But I will talk to him about that. So if we did Wednesday to Wednesday, do we just need to turn in a modified just to change it Wednesday to Wednesday?
If you can agree to a parenting plan with that change, you could submit that and call it an amended parenting plan. If you can't agree and you need the court to intervene, then you can note it for a motion on that issue. Okay.
And there's no way that I can have him not pay the $645.
Not the what's owing. So The total that's
Okay.
owing is $645. Going forward, so February on is going to be zero.
Okay, and that's what I want, because I mean, he has her 50-50, so there's no need for him to pay support at all.
Thank you.
Well, I think
You're welcome.
I think it's appropriate to have Mr. Roden put Georgia on his health insurance.
Okay, I mean, if that's going to be better.
So long as she's on your health insurance, then child support will be at zero.
Okay, and so on the health insurance, I'll just talk to him, because I think that still means if he can't take her to an appointment, I could, even if he's on her health insurance and stuff, we could figure that out among each other.
She should be assigned a number.
Okay.
And patient number and that
yeah, if it's better for him that way, and if that's going to make it where he doesn't have to pay child support, let's do it that way. I don't want child support from him. He's there for his daughter.
Okay, good. All right, it sounds like as parents, you're doing a very good job, and I commend you on that.
We're trying.
And I've signed the order that takes care of those issues, okay?
Okay.
Your Honor, can I clarify?
Go ahead.
Did you interlineate under paragraph 20 about the requirement for the father to provide private health insurance?
I did not put that in, so let me do that.
And
how can I pay?
So I'm going to take out the paragraph that says public health care coverage.
Well, please leave that in, because that is just a finding that identifies that the child is currently on public health insurance. So if you could leave that there, maybe cross out the last sentence about all parents must enroll if up to 25%, and then add a sentence that the father must provide private health insurance even if it exceeds 25% of his basic support obligations.
And I don't know, I know at one point she was on insurance through my work at one point, but I think they still keep the state medical. And I think what happens is if Taylor's insurance doesn't cover all the expenses, the medical will pay for what expenses need to be or are left to be paid for, I think is how it works, if I remember right. So I'll look into it, but I think that's how it plays out.
I had a question.
All right.
If I could. So the $645 that's owed, how am I able to pay that?
You can pay that, I think, to the child support division.
Child support division.
And
like
on the paperwork you got would be the address and phone number.
Okay.
For the child support division. Call them and they'll give you the information on that.
Okay. And then when it comes to any sort of bills, like medical bills, we are responsible both 50-50.
No, I think you're responsible in the proportion to your income.
Okay. And then also in regards to TANF, there's going to be no more TANF taken by her? Like I don't have to go through this again in regards to her.
Well, unless she signs up in the future. So
is there a time?
We get along for the most part. We've had our ups and downs, but I don't want child support from him. He's a good dad. He takes care of Georgia. So for the most part, we've gotten along and figured it out.
Okay.
Yeah, I was just making sure that she's not allowed to be on TANF. Like it seems like the state continues to do that, and that was just my question. That's it. I'm going to take what I got today.
I don't know that it's a question of whether she's allowed or not. Right now, she's not choosing to be.
Gotcha.
I think if she chose to be in the future, she could be, but I don't know what the future holds. Okay.
Thank you, Sir Nelson.
All right. Thank you.
Thank you. Bye.
Backspace.
All right, we're here for a request for child support. And last time we were here, I indicated I would agree that Mr. Cahill's income was $90,000, that he would owe child support. The issue was how much. I've been provided with a proposed order that includes an addendum. See the addendum, but the addendum where there's a shared residential split shows child support owed of $357. So Ms. Gomer, I assume that's your position at this hearing?
Yes. And then I frankly have never had a case where if there's a resident, if the parties have one child living in one residence and another child living in another residence, that the court hasn't adopted this formula. And that should be on the first page following the child support order, and that breaks down the math of that. But yes, we are asking the court to adopt both the child support order as well as the worksheets. I think the one point of contention, and I don't know Ms. Counts if she's reviewed this, I do apologize, I presented it on Monday, but we are asking that he claims taxes for both children every year, given the fact that he has Neil a vast majority of the time, and he's now paying child support for Elizabeth. So that's the basis of a request regarding taxes.
To the amount of child support and also the tax issue.
I don't have any objection to the amount of child support. It was actually higher than the amount that I got when I did the paperwork myself through the website. I do have an objection to the tax filing. When you read the code for tax filing, it does say that he has to provide Lizzie with 50% of her income or support her for more than 50% of the year. $300 and something is not 50% of the $1,014 that it is accrued for monthly costs for each of the children's living. And so I'd ask that that part be removed. The other thing that I had an issue with is that they set the start date for child support at February 1st. I would ask that that be changed to December 1st, as this was supposed to be ruled on back in December. And it just kept getting pushed over and pushed over. Other than that, I don't have any kind of issue with the paperwork. It all looked in good order to me, sir.
So I'm not going to let the father claim both. So I'm going to make a modification here. In terms of the start date, if there was a delay, that was the court's delay. I don't think that was Mr. Cahill's doing. And I think a February 1st start date is appropriate. So that's when the amount should be paid. So that would be beginning this month. Other than that, I do think the calculation provided by Ms. Gilmore is correct, and I will sign the order.
Can I ask just one clarifying question, please?
Let me just finish getting this ready here.
Thank you.
Yes, Ms. Jackson, go ahead.
I was just wondering, are we starting the filing credit for the taxes since we had a swap with the kids? I was just wondering if Mr. Cahill is planning on claiming Elizabeth for last year or Neil, if we should go based on the order that is in place today or the previous order for the tax filing year.
I think that's a really good question. I think the children did not switch really until last year, but I think last year Neil was living with you and Elizabeth with Mr. Cahill. So I think and there was no child support paid during that time. So I think it's appropriate that you each take a deduction for last year. Technically you may claim the opposite child. So Mr. Cahill should claim Elizabeth and Ms. Jackson should claim Neil. And then starting in 2023, the order I just signed would go into effect where Ms. Jackson would claim Elizabeth and Mr. Cahill would claim Neil.
And that's what I was actually looking for when you were signing the orders. I was looking back at the 2019 order and it actually reserved on taxes. So if the parties have filed, I'm assuming it's based on agreement of the parties, but there was previously no order. Okay, well, I think it's appropriate to do it that way for 2022 and then 2023, the current order. Jason Chappelle.
I see Mr. Chappelle is here and Ms. Smith is here. Is Shauna Ray here? Okay. Mr. Chappelle, did you see the 2-page email from Ms. Smith? It
yes,
looks like to you. So since we last got together, 2 questions have come up, and I guess we need to address that. One is, how long have the children been living in Shelton? Because one of the issues is whether the county, that county, and I'm not sure which it is, whether that county has now acquired jurisdiction over this matter because the children had lived there long enough, which typically is 6 months. The second issue is apparently you're not watching the kids now, Mr. Chappelle. It's Ms. Jessica Jo Chappelle. I'm assuming either that's a sister or a mother.
That is my wife.
That's your wife. Okay. So that's the stepmother that's watching them. Is that right? Or are you back home at this point?
I have 10 more days where I'm at.
Okay.
I have been in constant contact with my wife, and since the previous court hearing when the kids changed from the mother to me.
I'm here.
All right. So Shauna Ray is with us now, kid.
Right.
I
believe sometime in July, we moved to, which was the Gethsemane Ministries, which is right outside of Shelton. So they've been in the same area for over 6 months.
The other issue is whether we needed a minor guardianship action because
yes,
at this point your wife or the stepmom was watching the children, but it sounds like you're going to be going back home in 10 days. Is that right?
Well, in 10 days I'll be able to most likely be able to attend their anything to do with their schooling, counseling, and also be able to work with the WISE program. But I'll probably go into a sober living house for a month to help set up a solid recovery plan for myself, because for my continued sobriety.
Ms. Smith, why don't I hear from you, and then Ms. Ray, I'll hear from you after that.
Yeah, Your Honor, so as I previously provided all the parties, this was just a condensed review. I just wanted to put something on paper for people to be able to read and have the same information. So the children have been in father's primary care since approximately April. Considering that, there's also the acknowledgement that during summer, it was ordered that the parents would exert 2 weeks on and 2 weeks off, that type of schedule. And then the children would begin residing primarily with father when school went back into session. The children did reside with father at the Gethsemane Ministries for a short while until they began residing with Miss Jo Chappell and father at a residence that Miss Chappell had been able to secure in Shelton. It was provided to me that father did have a relapse approximately a month ago and immediately engaged in inpatient treatment. I've requested those records and have had a few hiccups in trying to secure data to confirm engagement, participation, length of stay, recommendations. So those are forthcoming. But in the meantime, we do recognize that Miss Jo Chappell is providing care. She's scheduling appointments. She's participating in school check-ins. She has largely been the one doing majority of this work, mental health, the whole 9 yards. I guess we have another huge hurdle. And so I guess that caused me to believe that maybe jurisdiction wasn't appropriate for Cowlitz. But I did want to bring that to the court to consider. As far as visitation, if the court does decide to keep that Cowlitz still has jurisdiction over this matter, I just request that the court would require the parties to begin and continue using the co-parenting app that I've provided them. It's a free app. I'm able to observe the communications that are going on. They are able to manage calendars, doctors, contacts, set up phone calls. They can do it through the app. They can schedule another time to call outside of using the app. And it doesn't cost either of them. There's a significant issue with, or an allegation that there is an abundance of communication from one party, while the other party says that there is a minimal amount of communication. This is a reoccurring theme. It's not helpful. It definitely creates a lot of tension and angst. That's a lack of trust being built between co-parents. So I just ask that app be required. And then lastly, should we maintain jurisdiction over this matter, we have the supervised visitation. Both parties have engaged in their intake and participated in that. It was requested that father and wife had reached out to mother to see if there is a mutually agreeable place in between the two locations to exert supervised visits. I wasn't aware of that at the time, and I had provided mother with the two known visitation supervisors that are here locally. It's father's request that maybe we review that and see if visitation can be established in a mutually agreeable place. Noting that I know that mother does not have a vehicle currently, and if she will be paying for the supervised visits, that may be more challenging and impactful than helpful to maintaining the parent-child relationship. We do have some safety concerns and some health concerns related to the children. The oldest child, Braden, has substantial behavioral issues, has been a long-standing issue. He continues to have those challenges. He's engaged in mental health counseling. He was just referred to and started engaging in the WISE program. That's a tremendous support for kids similar to Braden that have really significant emotions and an inability to manage those emotions well. That will serve him well. I'm so happy to see that he's engaged in that. I have school records that are pending. I've tried 3 times to at least get attendance and grades. Those are forthcoming, and I can provide that in a report should the court decide to keep this case, or otherwise this case might be more appropriate in Mason County. So if you have any other questions or points of clarification that you would like, I'm happy to answer those for Your Honor.
We still do not have a drug test from Ms. Ray at this point.
Correct. So father requested Ms. Ray to submit to a UA at the initiation of his motion. It's alleged that she never received that documentation and did not submit to that. Upon the order from Your Honor, she did contact Performance Occupational. She arrived there close to closing time, did not provide enough of a sample, and did not follow the protocol at the facility. So the letter that I received from the provider was that it was a refusal.
Ms. Ray, you've heard from Mr. Chappelle and Ms. Smith. I want to give you an opportunity to respond.
Yeah, I had problems getting on, so I had to call in. My concerns is Mr. Chappell's not in home. The parenting plan clearly states that the children are to live with Mr. Chappell. Doesn't say anybody else but Mr. Chappell. And so that's why I withheld the children from him, and I was wrong in doing that. I do not have a vehicle. That would be a huge impact on me as far as like trying to get there and see the children, and I feel like I've had my rights taken away in a sense. I don't have any communication at all with Mr. Chappell. It's all with Joe, his wife, and that's even limited. She don't answer phones. I have not still yet been able to talk to my children at all. And she states that it's because she doesn't want to, like, overstep the boundaries or whatever. Nobody said that I couldn't talk to my children over the phone, but that I had to have supervised visits. And I have gone, I've gone to places, I'm set up to see my children supervised, and we're on hold right now, I guess, to see where this goes, if it's going to be passed down to Mason County or not. I did go do a UA, and I flushed the toilet. So that was, what are we going to do with that situation?
Are you able to go back and redo the UA, say by Friday?
Yeah, my problem at that time, Your Honor, was the money. I'm Social Security. I get paid every third, and that was the only problem. And then the third came, and I was like, well, here we are. And he gave me only until it was like 2 days after the last court hearing. So it ain't going to matter what I do at this point. So let's go to court and then see what he wants me to do again. That was the only reason why it is what it is now. I don't know what, at this point, I just feel like everything was taken from me, and I'm sorry that I really don't know what to say. I'm kind of shocked.
Okay.
Yeah, I'm not understanding why nobody's looking at the, I understand that I live with my grandma and my situation, and I'm unclear as to why Mr. Chappell's able to keep relapsing and just jumping back into a life where he's at right now to get help, and that behavior is acceptable for you guys. I don't.
Right. I'm not sure it's acceptable to the court, but we'll address that in a minute. Okay.
Yeah.
All right. Mr. Chappell, I'll give you a chance to respond to all this briefly, if you want.
On my behalf, there's no excuse. I've been looking out for the best interests of the children, and in doing so, it's come to my attention I need to address my emotional and mental well-being. I mean, so in Shauna's case, she has never put the best interests of the children first. It's always been all about her. And her not being able to address any of their requirements, schooling, attendance, and counseling. When I went to pick them up, only twice has she had the kids ready within 5 minutes. Otherwise, it's taken up to an hour.
Yeah.
So I've been, holding myself accountable, and I have not been asked to. I've been asked to address my rehabilitation, but I went to the point, putting myself in inpatient because I understand this is a disease. It's a disease of not addressing emotions and feelings and other things. And, drugs are a way to a solution of not looking at yourself. And I want to get to know myself better so I can, be a dad for my children that, is productive in the community so I can lead by example. And, me and my wife are a partnership. And, I admire her and all she has done for the kids. It's showing me that she's part of my support system and the kids' support system. And any and everything that's been asked of me, she has helped me with. And everything I'm addressing in my rehabilitation is things she has done and asked of me beforehand. And so therefore, that is why we're filing guardianship, because I plan to go fishing out of town and I want my kids stable, consistent, because it is their best interest to be able to thrive in the future. It's been asked of Shauna to explain why she hasn't been, doing what's asked of her. And all there is excuses, and there shouldn't be for the children. There should be no excuse for the children.
What's your excuse?
All right, Ms. Ray, and it's my turn now. All right, Mr. Chappelle, it sounds like your wife, Jo Chappelle, is doing a great job with the kids, but that really kind of misses the point here. And the point is that we have two parents and the children are now staying with a non-parent. And that isn't sanctioned by the court. That's something that you on your own decided to do. And maybe that was a good decision or not, but it has to be sanctioned by the court. Jo Chappelle needs to immediately file documents for a minor guardianship of the children. Now, Ms. Ray, you will be served with those documents and you'll have an opportunity to oppose that. But we need to go through the court system to see whether that minor guardianship would be granted. That needs to be filed in Cowlitz County, okay? And part of that is they're gonna ask you about any pending cases. Make sure you list this case as a current case and that is going on. I need Ms. Ray to do a UA by this Friday and provide the results to Ms. Smith.
Okay.
So we don't have to keep coming back. If Ms. Smith will forward the results to me and Mr. Chappelle, and if they're negative, then we can resume supervised visits, which are, I understand those are in Cowlitz County right now because Ms. Ray can't drive. And so unfortunately, the children will need to be transported to Cowlitz County, at least in the near future. Okay.
Your Honor.
Today's the 8th. Go ahead.
She's in Castle Rock, and for visitation, we'd have to travel past her, and the Castle Rock place is $45 an hour. So the one in Chehalis, which is maybe 45 minutes away, is a sliding fee scale. So hypothetically, if she was to have a usual 2-hour visit, it would be less than traveling back this way for the extra 20 minutes or so. I mean, this is about the kids and that long trip. I mean, if the courts understand that Miss Ray would make it, put the kids first, she should be able to find a way to be able to address the travel time.
I understand that's an issue. Sir, I'm going to set a review a month from now on March 8th. The supervised visits will remain as they are until that time. I would like you to present to me on March 8th alternatives to what the current system is. So you're telling me there's a place in Chehalis. I don't know anything about that place, but maybe you can inform me about it. Or some other location. I need more information before I can make the change, okay? So we're over a month. If Ms. Ray has a clean UA, then we can resume supervised visits, and we'll do those in Cowlitz County for now.
Yes, Your Honor, we submitted that information during her violation of the parenting plan. We gave suggestions. Something else that hasn't been addressed is the Joshua Wymore thing about
Josh Wymore's not in the home. And I have a restraining order sitting right here in front of me to fill out to bring back in today.
Yes.
Well, because I missed my hearing. Because I was in an appointment doing what I was supposed to do at the same time. Is why I lost this restraining order.
What is, Ms. Smith, what is the parenting app, again, that you would like the parties to utilize?
It's called App Close, AppClose. It's all one word.
What I would like for Ms. Jo Chappelle to try to obtain that app, and also for Shauna Ray to do that. One last thing, sounds like there may be some concern about this. I would like Ms. Ray to be able to call the children at least once a week. And so let Ms. Jo Chappelle know that that's appropriate. Yeah. And I'll let Jo Chappelle and Ms. Ray figure out a convenient time to do that. Sounds like Jo Chappelle wasn't sure if she should do that. So now I want to clear the way for that to happen. So there should be one phone call. Okay.
So yeah, the prior order from the trial said that both parents had liberal access to phone communication with the children while in the care of the other parent. So if I'm understanding, and I just want to make sure that we're clarifying that it's one time per week at a mutually agreeable time. Is that what we're?
Yes.
Okay, thank you.
We'll do that until March 8th, okay?
Your Honor.
All right, briefly, and got other cases I need to do. Go ahead.
Okay, so we did set something up last weekend, and she failed to call and on the appointed time, and
That's bullshit.
the app close thing,
That's
my
right.
wife has already filled it all out and it's on there.
All right. We're going to go forward at this point. So Ms. Ray and Ms. Joe Chappelle are going to work out a mutually convenient time to make the phone call happen. Okay.
Thank you.
All right. All right. Thank you, everyone. I think your temporary order is basically wanting to change the parenting plan. Is that right?
Correct. I have one of the children in my custody now, but that order expires on February 15th. And then obviously I'm asking that the second child be placed with me as the siblings are separated. Mr. Harrington's having open heart surgery. So my child will be left with somebody else anyways.
Mr. Harrington, what Ms. Harrington is indicating is since you're going into surgery, that the other child should be placed with her until you go to court on the change in the parenting plan. Do you have a response to that?
Yeah, I disagree with that. I'm only going to be in surgery for a day and then recovery in the hospital for 3 days. So then I'm home for the rest of my recovery after that. So I don't see why he should be placed out of the home for that. And I don't know if you were able to read any of my other paperwork, but there's multiple other reasons, but I disagree with that. So.
I did read your paperwork.
Can I respond, Your Honor?
Let me ask a couple questions first. So, which child is residing with you right now, Ms. Harrington? All right, and Arian is residing with Mr. Harrington?
Yes.
Correct.
Is there any visitation going on with the children? I guess there's a protection with Christine.
I see Arian every other weekend.
Okay. And Mr. Harrington doesn't see, right?
No, only talk to her on the phone.
That's because of the protection order.
Yes.
Yeah, they do have phone conversations.
Okay. Okay. Ms. Harrington, you wanted to say something and then I'll let you know what I want to do.
With Mr. Harrington saying that he only has the 1 day of surgery and 3 days recovery in the hospital, they live in a place that requires water to be transported in and uses wood heat only. And Mr. Harrington is going to be unable to do those things for quite a bit longer than that. Chop firewood, haul it in the house, provide water.
Is there anybody else that lives there that does those things?
Yes.
He does have a girlfriend, but it's pretty heavy lifting. I mean,
I read both of your requests for temporary orders in this case. And what I think is the appropriate thing to do until you get to trial is maintain the status quo. So that means that will remain with Ms. Harrington. And I'm going to extend the protection order until the date you go to trial on the parenting plan. If there's contact by telephone, then that can continue. In terms of Arian, they will remain with Mr. Harrington with the every other weekend visit, as you've indicated. See why I don't believe that there's a need for a major change at this time. Let's take up the issue that was for today, I believe, which was to address the supervised visits. And I think Mr. Llewellyn, his former landlord, could serve in that capacity. Is that still your request, Mr. Llewellyn?
Yes, Your Honor. With Marie Woodage, correct? That's what you're speaking of?
Yes. Yes.
Yes, Your Honor.
have you known her just as your landlord, or give me a little more background on how you know?
I have known that family since childhood. Matthew Woodage, who I was staying with, is a childhood friend who my mom used to babysit, and I've really known them basically my entire life, as far back as I can remember anyways. And I know that there's concern about Marie not being around bipolar and whatnot, but seeing as how she is a family friend and has my mother's contact number, if anything were to happen, she's smart enough to know when something's not right, and she could call my mom and my mom could help in that situation.
Okay. Ms. Burkett, what's your feeling at this point?
I just have one concern. It's mostly just that previously Shane's mother did the supervising of the visits, and that was going well up until a point where she had to call the police to have him arrested. And I worry that, you know, one woman isn't going to be able to really do much. Things do go sour. Shane can be a little bit, I mean, he's a lot stronger than she is, and that's my main concern. I do like that she's a family friend and that, you know, we do have connection with her, but I have never met her as well. So I'm not entirely sure who this woman is to me or Abel at this point.
Okay.
Your Honor?
Yes, please.
And even in the time at my mother's house that things did go awry, I guess, I never did anything to anyone. I just tried to go in to see my son when they had told me to leave. And it was my visitation day. It was actually on Father's Day and the following day. And the following day, I went to my mom's house to see my son. And she said, "You're not welcome here, leave." And I went into the house to try to see my son, and that's where things went wrong.
Mr. Lawrence, any comment just on the supervised visits with a non-professional supervisor?
Your Honor, Marie Woodage, her name came out at towards the very end of this investigation. Ms. Shoup, his original landlord, had decided not to provide supervision for his visits. So I don't know her that well. And I didn't know if Tasana knew her at all. And I asked Ms. Woodage to provide a list of her job history, because she was a long-time employee at WorkSource as well as an after-hours counselor and caseworker for DCYF. So I thought that at least brought her into the ballpark of working with folks that have issues. But again, I didn't know what Tasana's feelings would be until she actually met this woman. And so that's why I made the recommendation that Tess make contact with her so they can discuss this issue and decide whether or not she might be appropriate.
All right, I do think that's appropriate. So I'm going to, I'll give you my decision on that after we address the relocation issue, because they're somewhat intertwined. Ms. Burkett, I've read all of the material. I've read Mr. Lawrence's report, so I understand your desire to relocate to Hillsborough. If you want to just address that briefly, and then I'll give Mr. Llewellyn a chance to reply.
Yeah, absolutely. So my boyfriend and I decided that it would be a good move to move in together. He has a 2-bedroom, 2-bathroom apartment in Hillsborough, and we're speaking about buying a home. Right now, the real estate market is pretty crazy, but once the housing prices go down, you know, then we're looking to buy a home there as well. He works at Intel as an electrician, and he makes a very good income, a lot more than I do. So that's why it made more sense for us to move to Hillsborough instead of him to move here. It'd be a lot harder for him to find a good career like he has there. And Abel absolutely loves him. we spend a lot of weekends there already, just hanging out and going to the arcade, playing football. Steve taught him how to catch a football. By the end of the weekend, Abel really doesn't want to come home. Like he asks, like, why are we not staying here? I have a bedroom here. So I just feel like it would be good for Abel to have that family unit all the time.
You're willing to do the transportation for the visits with Mr.
Absolutely, yeah. I understand how important that is, and Abel is starting to look forward to those visits every other weekend, and we have more than enough reliable vehicles to do the transportation as well. So it won't be an issue whatsoever. The only thing that stands in the way of the visits is just if Abel gets sick or if the weather conditions are bad. But other than that, it'll be our priority to make every one of them.
I hear everything Tasana's saying, and I can't say whether it's true or not, but I do know that one of the times fairly recently that Abel was at my mom's house, my mom, we kind of had an idea of what might be coming. And my mom asked Abel just straight out, so are you going to be moving? And Abel said, I don't want to talk about it, Nana, which leads me to believe that there's some hesitation in his mind to where he probably doesn't understand the word, but an objection. And I don't want him to be upset. And it seems though, as I had stated in the paper, that since his finding out about the move, that he has started wetting the bed, which is not typical of him, at least when he's at my mother's anyways. And he has started acting up in school according to his teacher, because my mother is a teacher as well. And they speak with each other. And it's not typical for him either. When he first started school, he was very good, attentive, and he had friends. And then he started acting up around the time that I would assume was when he heard about the move.
Do you have transportation, Mr. Llewellyn?
Yes, Your Honor.
Your own car in that. Okay. Mr. Lawrence, do you want to address the what's to move to Hillsborough?
Well, Your Honor, right now Tess has been living with her parents in Woodland. She has not been able to afford a place of her own. This opportunity is kind of a twofold opportunity. Number one, I'm assuming that the relationship between these two is a very positive one and good for all. The other thing is that this gentleman does make a substantial income and would thereby provide an opportunity for Tess to move out of her parents' home and be able to live a life on her own. And they have been staying every weekend down in Hillsborough. I'm not sure of the timing on the incidents that Shane is referring to, whether that was before they spent time down in Hillsborough on the weekends, or whether that occurred after they've had a few weekends down there. I can understand that the transition is going to be difficult for anyone. Even Tasana is going to have some adjustments to make. But when you're looking at the overall development of a 5-year-old, soon to be 6, his world is pretty much tied up with his parents right now and his family members. And he doesn't have a lot of roots in the Woodland community except for family members. And I don't hear anybody talking about diminishing any of those contacts. So I think if he was to move, now would be a perfect time to do it, because Tasana does not want to interrupt his kindergarten. And so therefore she's going to allow him to finish, and then would like to move in the summertime so he could start fresh as a first grader in Hillsborough. And that sounds like a very good plan, and one that would help to minimize some of the issues for Abel.
Your Honor, can I respond to what Shane said earlier?
Sure, go ahead.
On my end, Abel has not wet the bed at all. There hasn't been any issues with that. I'm not sure exactly what's happening over at Michelle's house, but there's nothing on our end as well. And I'd like to say as well, if he was doing badly in school, which he isn't, his teacher says he's doing great and his favorite subject is math. He can get a little distracted, but this is his first year of school. He is a kindergartner. But if he was, it would have happened right about the time that these visits with Shane also started. So I'm not sure if we can really pinpoint it 100% being on the move. It could be a lot of different changes in his life right now, like him not seeing his dad for over a year, and now his dad is now in his life again. And I just don't think it's fair to pinpoint it on that one thing.
Your Honor, may I say something?
Briefly, please.
So our visits have been going on for a couple of months now, and Abel's acting up. My mother told me about it about 3 weeks ago. So I don't know. That's all I wanted to state.
All right. Thank you. What I decide is whether there will be a temporary order allowing a move. Ultimately, if you cannot agree, you're able to bring this in front of one of the judges and do a hearing or a trial, actually, where there's a number of factors that are looked at to determine whether the move should be allowed. I will tell you that the way the law is written, there is a preference to allow the move by the primary custodial parent, and that's Ms. Burkett. So when you go to court, I guess I'll let you know that it is weighted in favor of allowing the move. Plus, at this point, Mr. Lawrence has indicated that he feels that it would be in the best interest of the child. So on a temporary basis, I'm going to allow the move. I'm going to deny the motion to prohibit the move, which is the motion that's on for next week. The move should occur after your child completes kindergarten, so he's not disrupted in this school. Ms. Burkett will be required to take the child to the supervised visits on whatever basis they're set up, and she'll provide transportation. I would like her in the next, say, 2 to 3 weeks to meet with Ms. Woodage and discuss the bipolar issues with her to see if both Ms. Woodage and Ms. Burkett are comfortable with Ms. Woodage stepping in as the supervisor. If you are, then that switch can be made. I'm going to make it somewhat subjective. So if Ms. Burkett is not comfortable, then we're not going to make that switch at this point. But I'm going to trust that you'll talk to Ms. Woodage and we'll give her a fair evaluation as to whether she'd be an appropriate supervisor. Okay.
Absolutely.
So that's what I'd like to have happen. And that change to her can occur without coming in front of me again. I'd like to set a review on April 26th.
Okay.
Your Honor?
Yes, go ahead.
I do have a concern. I don't necessarily know Tessa's mind, but I do have a concern that she will just say no because she wants the visits to take place at the Reconnecting Families. But I also would like to say that at the Reconnecting Families place, whenever there's someone watching us, like through the door, they just peer in. It makes Abel and I both uncomfortable, and we're just in a little tiny office room. So I feel as though it would be far better to be in a home setting where there's like a hot tub and We can play in multiple areas. There's a playground right down the street from where Marie lives, and we could be outside. We're not limited to a tiny little room where we can't really do a whole lot. And it's the same toys over and over. That, yeah, I get that, but being able to bring my own toys and presents for him, which I can't necessarily do all that often at this place, the Reconnecting Families, because really on Christmas and my first visit was the only time that they allow presents. And I understand the reasoning for that, but being able to buy my son presents and let him play with those, it would open up a variety of toys instead of just what we're limited to there.
All right, I agree with you on all of those points, except the one where there's an assumption that Ms. Burkett is just going to say no.
That's just a concern, Your Honor.
What I've heard during these hearings is she's very supportive of your relationship with your son. Clearly wants what's best for him. I think it's your son. And I feel that she's going to talk to Ms. Woodage, and if she feels comfortable, she'll agree to it based on her representation. But I don't want to lock her into that. And I don't want to lock everybody into that. I feel that there needs to be some interview process, maybe some training. I don't want to make a decision that, again, locks everyone in. So the best I can do is say, meet with her. I know it's subjective. Hopefully it will work out because it's going to save money and make it more flexible and give a better location for the visitation to occur. But if Ms. Burkett is not comfortable and she says no, then that's something we can address when we come back in April. All right, this is a motion for adequate cause. Let's hear from Ms. Day first, and then I believe Mr. Nonamaker is the respondent, so we'll hear from him and his counsel second. Ms. Day, do you want to explain to the court why you would like order for adequate cause to allow you to change the parenting plan?
Yeah, well, first reason was because my schedule for work has changed. Our last parenting plan, I was working nights, and now the plan is not reasonable. I mean, I get her from school, come home, cook dinner, eat, and have to go drop her off at dad's house. There's no time for spending time together, and it's not reasonable. I asked him multiple times to do week on, week off for the school year, and he didn't agree, so that's why I took it to the court instead. That's why I filed for full custody. I would rather have week on, week off because it's fair and it's better for our child. I don't know what goes on in their house, but I do know that my daughter, I'm thinking it's a parenting schedule right now, and the changing over the last year has affected her mentally. She's acting out. She got put in a class at school for parenting change or family change, and I would like to be in charge of her mental health. I think that she needs to go to counseling, and he told me that he doesn't believe in counseling. So we're at that spot. I would really actually like week on, week off, to be honest with you, not what I filed for, but he wouldn't agree with me. So I went for full custody just so that I could have range of what needs to be done for our daughter in her best interest.
What is the current visitation plan? I mean, what do you do like last week, the week before?
So our parenting plan is he has her Monday through Thursday from 6 p.m. to 8:30 a.m. and then every other weekend. So I'm supposed to have her from 8 a.m. to 6 p.m., but she's in school from 8 a.m. until almost 3. And so I'm seeing her for 2.5 hours and dropping her off at her dad's house. And during the summer, we had week on, week off, and it worked great, and she loved that schedule. But they're saying that, and part of the beginning of the school year, when me and his wife were both pregnant, and it's easier for us to do it that way, I just feel that overall she acted the best when she had it that way.
Part of the reason you're asking for the changes because of the change in your work schedule?
I worked nights when we did our original one, and now I work from 5:30 in the morning until 1:30 p.m. So basically why she's in school.
So you see her from 1:30 to when he gets her in the evening, is that right?
Well, she has school, so I only see her from 3 o'clock until 6 o'clock.
Okay.
And then every other weekend.
Thank you. Ms. Colley?
Thank you, Your Honor. So I want to just note that it is Ms. Day's burden here to prove adequate cause based on the affidavits submitted with the petition. Her declaration statements are very slim. They don't provide any evidence to show what she's alleging here today in her argument. There's nothing that shows what the child is going through, any behavioral problems. There's no evidence of actual harm to the child and detriment. Her actual petition. Also, additionally, first, I'd like to, Your Honor, ask that the court not consider the two late filed declarations, supplemental declarations that Ms. Day filed after we filed our response. Those materials were by two additional witnesses that should have been filed with the original materials so that we would have had the opportunity to respond to them. We weren't given that opportunity. So I would ask that the court not consider them. If the court were to consider them, I would like the court to understand that much of that, what is contained in those is child hearsay statements and not statements made by actual witnesses to events. The declaration statement by Ms. Day and her petition don't provide any basis for detriment that she alleges in her petition. In her petition, she fails to check any information as to integration. She's not pleading, she has not pled to modify the parenting plan based on integration. She has pled to modify the parenting plan based on detriment in father's home and the environment in father's home, but yet she fails to prove that. As the court's aware, custodial changes are viewed as highly disruptive to the children, and Washington law makes it very clear that there's a strong presumption in favor of custodial continuity and keeping the parenting plan in place. Ms. Day presents, for Your Honor, an argument just based on her own preferences because her work schedule has changed. Again, not contained in the pleadings that was with the affidavits on the petition. But that preference to have more time is not something that would be a basis for modification. The adequate cause threshold is very high for major modifications. She's asking to go from something that is essentially close to a 50-50 parenting plan. But if Your Honor looks at the final parenting plan that was entered on December 28th of 2021, just a little bit over a year ago, this parenting plan provides for father to have every other weekend and then all week from 6 p.m. to 8 a.m. the next morning. What that does is essentially provide father with nearly a 50-50 plan here, and that father should be, despite the fact that Ms. Day is listed as custodian, he should still have that still continued right to have that time with the child and should not be modified out of that time based on allegations that aren't proven here.
Ms. Cohen, that plan was obviously put together because Ms. Cohen was working nights and, or Ms. Day was working nights and needed to basically provide daycare during that time. Now that she's working days, doesn't that suggest that there should be some change in the plan to accommodate her new work schedule?
Suggest that she needs to accommodate the plan. The child's in school, whether she's working or not. So that time that Ms. Day is speaking to, each parent has times where they don't necessarily spend all of their parental time with the child. It's very frequent for parents who are working to have daycare. The child would be in school during the time that Ms. Day is requesting. And furthermore, father has time where the child is sleeping during the night. So each parent is going to have time where they're not actively participating in those waking hours with the child. And that's normal for parenting plans. And that shouldn't be the basis to modify the parenting plan. Again, also, she did not allege it in her initial pleadings that would be the basis. Her basis was that father was inconsistent with his time and that he couldn't financially provide for the child. We provided documentation that showed the reason why that he was inconsistent with his time, or that there were changes. Those were temporary changes. This defeats any argument also on integration. These were temporary changes, and he never consented to a final parenting plan or a change that would be permanent. We provided the medical record to show why that was. He is married and Ms. Day, despite her own declaration statement that shows that she made actual threats to his wife's life by talking about shooting her in the head. Mr. Nonamaker's wife's statement that furthermore that Ms. Day made threats physically to punch her in the face as well as to harm her and end her life. So I think that shows that the detriment actually occurs in mom's home, that mom's influence is more detrimental to the child than dad's. She fails to prove that there's any detriment in dad's home, that there is any issue there. The stepmother does provide transportation. That is the reason why Mr. Nonamaker had to make temporary changes to the parenting plan, because he needed to be able to accommodate that issue while she was having a medical problem. She was pregnant, and we provided the medical record to show that she had a very severe pregnancy that resulted in essentially very high resulting morning sickness, and ended up in the hospital several times and having to have injections. Those changes to the parenting plan were made to accommodate that issue. But going forward, there is no basis under Washington law, under the statute, to provide a sua sponte change to the parenting plan by the court, or based on the allegations alleged by Ms. Day. I just don't think she has met her burden or provided any of that proof. I could go into more further statements on integration, but I think that that's unneeded because she didn't even plead it at this time. There is no evidence that dad's environment is detrimental to the physical, mental, and emotional health of the child. And the change in the environment would be outweighed by the change in the current environment would be outweighed by what the detriment would be to change that in this parenting plan modification. So we are asking that the court deny adequate cause, that she has not met her burden, and allow the parenting plan to continue as it is.
So about the threatening her life, I never actually threatened her. I never said her name. I have notes that I could get from my counselor saying that I acted out for my PTSD, basically, because
Ms. Day, I'm not going to make the decision based on those allegations, so you don't really need to address those.
As far as his inconsistency, he is inconsistent. He got evicted from his home in May of 2022 and is now living with his in-laws. I have my own home. And what I originally filed, because he wouldn't agree with me, was the fact that he was inconsistent, and family change is a big thing for a 6-year-old. She is very confused, and at her house, well, her father's house, his mom made me cry. She's not allowed to call me mom at his house. She had to call me by my name and not to call Tabitha mom, which is not okay to me.
Again, Your Honor, we would object because these are not materials that were in the original pleadings. Had they been in the original pleadings, we would have responded to that, and that it's not true.
Okay.
And the witnesses that she provided supplement to that we are asking to not be considered, also do have no knowledge of what goes on in Mr. Nonamaker's home. They don't have knowledge to make that witness statement.
Let me discuss what the standard is and explain why I'm making the decision I'm making. So for adequate cause, we have to look at the Washington statutes, which are called RCW, or Revised Code of Washington 2609260. And I'll read part of it. It says the court shall not modify a prior custody decree or a parenting plan unless it finds, upon the basis of facts that have arisen since the prior decree or plan, or that were unknown to the court at the time of the prior decree or plan, that a substantial change has occurred in the circumstances of the child or the non-moving party, and that the modification is in the best interest of the child and is necessary to serve the best interests of the child. What the statute requires I look at is, have there been changes either relating to the child or relating to Mr. Nonamaker? The fact that there were changes in Ms. Day's life, or the change in her work schedule, is not something that the statute allows me to consider. Looking at the declarations that were submitted, I agree they were very thin in terms of any facts, and I will find that they do not create a substantial change in circumstance that allows me to grant in order for adequate cause. And so for that reason, I'm going to deny the motion for adequate cause. I'll also indicate this parenting plan has been in effect since, I think, December of 2021. It was agreed to between the parties. To me, that gives it actually a little bit more strength that that was something that they agreed to, they put in place. And again, I don't find that there's a substantial change in circumstance to change it at this point. So I'm going to deny the motion. Thank you.
Thank you, Your Honor.